If you have a joint bank account with your spouse, I want you to stop for a moment and picture something. It is the worst day of your life. You have just lost your husband or your wife. And somewhere in the middle of the funeral arrangements, the phone calls to family members, the paperwork that never seems to stop arriving, you realize you need to figure out what happens to the money you have shared for maybe 20, 30, 40, or 50 years. What happens to that account? Can you access it? Is it frozen? Does it go through the courts? Do your children have any claim to it? Does your spouse's will change anything? Here is what most people do not know until they are already standing at the bank counter, exhausted and grieving and completely unprepared. What happens to your joint bank account overnight when a spouse dies depends entirely on three things that were decided the day that account was opened. Three things most couples never paid close attention to on the paperwork because there was no reason to think about it at the time. Today, we're going to walk through exactly what those three things are, what happens in each scenario, what the bank is going to ask you for, what you need to do in the first 30 days, and the one simple document that almost every widow and widower wishes they had set up years before they ever needed it. This is not meant to frighten you. It is meant to make sure that if this day comes, or if it has already come, you are not standing at that counter confused and alone, trying to figure out rules nobody ever explained to you. Let us start with the scenario that applies to the majority of married couples in the United States, because it is genuinely the most reassuring place to begin. Most joint bank accounts between spouses are set up with what is called right of survivorship. You may have seen those words on the paperwork when you opened the account and moved past them without thinking twice. Here is what they mean in plain language that actually matters to you right now. If your joint bank account has right of survivorship, here is what happens overnight when one spouse dies. The surviving spouse automatically becomes the sole and complete owner of everything in that account. Not eventually, not after a court process, not after waiting for an estate to be settled. Automatically. The moment your spouse passes, full ownership of that account transfers to you by operation of law. That account does not become part of your spouse's estate. It does not go through probate, which is the court-supervised process that other assets often have to pass through before they can be transferred to heirs. A process that can take months or even years, and that costs real money in court fees and legal expenses. The account transfers directly to you as the surviving spouse, because the right of survivorship that was established when the account was opened is legally stronger than anything written in a will. That last point surprises a lot of people, and it is important enough to say again clearly. Even if your spouse's will says something different about that money, the right of survivorship on the joint account typically overrides the will. The will might specify that certain assets should go to your children or to other beneficiaries. But if the joint bank account has right of survivorship, that account transfers to you as the surviving spouse, regardless of what the will says about it. The account transfers by operation of law, not by the instructions in a document. So practically speaking, what do you actually need to do when this happens? You bring the bank a certified copy of the death certificate, not a photocopy, an actual certified copy with the official seal from the county vital records office or from the funeral home. They can obtain them on your behalf. Once the bank has that certified copy, they update the account to reflect that you are now the sole owner. In most cases, the account is not frozen during this process. It is a name change, not a lockout. You can continue to access the account while the administrative update is being processed. That is the part that should bring you genuine relief. If your joint account was set up with right of survivorship, the money does not disappear. The account does not get tied up in court. You walk in with a death certificate and you walk out as the sole account holder. But there are important exceptions to this that the simple version of this story leaves out. And these exceptions affect enough people that every person with a joint bank account needs to understand them before assuming the easy scenario applies to their situation. The first exception involves community property states. And this is the one that catches the most people off guard because it changes the calculation in a fundamental way. If you live in one of the 9 community property states, which are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, or Wisconsin, your joint bank account may be titled as community property rather than as a joint account with right of survivorship. And if that is the case, only half of the account may automatically belong to you as the surviving spouse. The other half, your spouse's half, could be treated as part of your spouse's estate. That means it might need to go through probate. It might be distributed according to what the will says. It might go to beneficiaries your spouse named rather than directly and immediately to you. The distinction between community property titling and right of survivorship titling is not always obvious from looking at your account. It is not something that jumps out on a bank statement. It is a detail buried in the original account documentation that most couples never think to revisit after the account is opened. If you live in one of those 9 states, do not assume you know how your account is titled. Call your bank or visit a branch and ask them directly to confirm the titling of your joint account. Ask them specifically whether the account includes right of survivorship or whether it is titled as community property without survivorship rights. That one phone call could mean the difference between a smooth overnight transfer and a months-long probate process at the worst possible time of your life. The second exception involves the size of the estate and the potential tax implications. And while this will not apply to most American families, the people it does apply to need to know about it before they are blindsided by an unexpected bill. In 2026, the federal estate tax exemption is $13.99 million per individual. The vast majority of American households are not going to be anywhere near that threshold, which means federal estate tax is simply not a factor for most people reading this. But approximately 17 states plus Washington, D.C. have their own estate or inheritance taxes, and some of those state-level thresholds are dramatically lower than the federal one. In Massachusetts and Oregon, the threshold is $1 million. In Maryland, there is both a state estate tax and a separate inheritance tax. In some states, certain relatives who inherit assets pay a percentage based on the value of what they receive, regardless of the federal exemption. If you live in one of these states, and your total combined estate, including real estate, retirement accounts, investment accounts, and all bank accounts, is anywhere near the relevant state threshold, this is a conversation worth having with a tax professional or an estate planning attorney. The joint bank account transfer itself may not be taxed as income, because as the surviving spouse, you already had an ownership interest in that account. But the overall estate tax picture in your state could still have implications for the total wealth transfer that occurs at death. Do not guess at this. The cost of a consultation with a qualified professional is trivial compared to the cost of being wrong about whether a tax is owed. The third exception involves the interest that the account earns after the date of death. And while this is a smaller detail than the other two, it catches people off guard because the tax treatment is slightly counterintuitive. When you take over the joint account as the surviving spouse because of right of survivorship, you are not treated as having received taxable income from your spouse. You already had an ownership interest in the account. Receiving full and sole ownership is not a taxable event. However, any interest the account earns after the date of your spouse's death is reportable income, and it is yours going forward. The IRS will see that interest income flowing to your Social Security number because you are now the sole account holder, and it will be treated just like any other interest income you earn. This is not a major issue for most people, but it is worth knowing so that you are not confused when you see interest reported on your tax documents in a slightly different way than you are used to. Now let us talk about the first 30 days, because this is the period when the practical demands of managing finances after a loss feel the most overwhelming, and having a clear sequence of steps to follow can make an enormous difference. The single most important first action is to order multiple certified copies of the death certificate immediately. Order more than you think you will need. Most people who have gone through this process recommend ordering at least 8 to 10 certified copies. You will need one for each bank where you and your spouse held joint accounts. You will need one for the Social Security Administration. You will need one for any pension or retirement account. You will need one for life insurance companies. You will need one for the Department of Motor Vehicles, if any vehicles need to be retitled. You may need additional copies for investment brokers, for any real estate transactions, and for various other institutions that require proof of death before they will transfer or release assets. Certified copies cost a modest fee per copy, but that fee is well worth paying to avoid having to reorder at the wrong moment. Your funeral home can typically obtain certified copies on your behalf from the County Vital Records Office, which is usually the fastest way to get them during the immediate period after a loss. Once you have those certified copies, bring one to each bank where you and your spouse held joint accounts. When you sit down with the bank representative, ask them 2 specific questions. The first is to confirm that the account is titled with right of survivorship, and that the transfer process is simply an administrative update to sole ownership in your name. The second is to ask about any accounts that were held solely in your spouse's name, because those accounts do not work the same way. An account that was only in your spouse's name, not joint with you, does not transfer automatically to you under right of survivorship, because there is no survivorship agreement attached to it. Those solely owned accounts typically become part of your spouse's estate and go through the estate settlement process. Depending on whether the account had a payable on death beneficiary designated, and depending on your state's laws and the terms of your spouse's will, accessing those funds may require going through probate or working with the estate's executor. The bank will tell you what they need to see to allow you or the estate's administrator to proceed with each solely owned account. Once the joint accounts have been transferred to your sole name, the next important step is one that most people skip because they are still deep in grief and managing everything else that needs to be done after a loss. But it is important enough that it deserves specific mention here. Once that joint account is solely in your name, go back to the bank and add a payable on death beneficiary to the account. A payable on death designation, sometimes called POD, is a simple form that most banks offer at no charge. It allows you to name the person or people you want to receive the funds in that account when it is eventually your turn. The payable on death designation means that when you die, the account transfers directly to whoever you named, without going through probate, without waiting for a court process, without months of delay. It is exactly the same protection you had through the joint right of survivorship arrangement, now applied to your situation as a sole account holder. Setting up this designation takes about 15 minutes at the bank, and it is one of the most important steps you can take to ensure your children or other intended heirs do not face the same confusion and delay that you might be facing right now. Do not leave the bank after handling the transfer of the joint account without also asking about adding the payable on death designation to your newly sole account. This is also the time to review your overall estate plan with an estate planning attorney if you have one, or to consider establishing one if you do not. A will or trust that was written when there were two of you managing shared finances may not reflect your new reality as a sole account holder managing everything independently. The people you named as executors or trustees may need to be reconsidered. The distribution instructions may need to be updated. The overall structure of how your assets will eventually transfer may need to be revisited to account for the fact that you are now the sole owner of accounts and assets that were previously co-owned. This is not something that needs to happen in the first week or even the first month, but it is something that should happen within the first year after a loss, while everything is still relatively fresh, and before life circumstances change further in ways that make the estate plan even more outdated. Let us spend some time now on a situation that comes up frequently and that most discussions of joint bank accounts do not address in enough detail. What happens when the joint account is not with a spouse, but with an adult child? Many older adults set up joint accounts with an adult child for practical reasons, perhaps to help manage day-to-day finances, to allow the child to pay bills if the parent becomes incapacitated, or simply to give the child access to funds in case of emergency. These arrangements are common, and they are often done without a full understanding of the legal and tax implications that come with them. When a joint account is set up with an adult child rather than a spouse, the rules work differently in several important ways. First, if the parent dies, the right of survivorship on the account would transfer full ownership to the child, just as it would in a spousal situation. However, the parent's other heirs, other children who were not on the account, have no automatic legal claim to those funds. This can create significant family conflict if the parent's intention was to share the account's assets among all the children, but the structure of the account only transfers them to the child whose name is on it. If this is your situation, or if you are thinking about setting up this kind of joint arrangement with an adult child, the structure of the arrangement and your intentions around it need to be documented carefully to avoid conflict and potential legal challenges later. Second, the IRS may scrutinize the contributions and withdrawals from a joint account between a parent and an adult child more closely than it would a spousal joint account. Specifically, if you as the parent funded the account entirely with your own money and your adult child makes substantial withdrawals from that account, those withdrawals could, in certain circumstances, be treated as taxable gifts from you to your child. The annual gift tax exclusion in 2026 is $18,000 per recipient, which means you can give up to that amount to any individual per year without gift tax implications. Most everyday transactions and withdrawals in a functional joint account management arrangement will fall well within that exclusion. But if the withdrawals are large, if the arrangement has features that look more like an outright asset transfer than a practical financial management tool, or if there is any ambiguity about whether the account was intended to function as a gift mechanism, it is worth a conversation with an accountant to understand the implications before any issue arises. Third, if the adult child on the joint account has creditors, legal judgments against them, or files for bankruptcy, there is a risk in some states that the creditors could reach the funds in the joint account because the child is legally a co-owner. The extent of this risk varies significantly by state law, but it is a factor worth understanding before adding an adult child to a bank account that holds significant funds. The practical guidance if you have or are considering a joint account with an adult child is to think carefully about whether the joint account arrangement is actually the best tool for what you are trying to accomplish. In many cases, a durable financial power of attorney, which gives a trusted person the legal authority to manage your accounts and finances on your behalf without making them a legal co-owner of the assets, accomplishes the same practical goal of ensuring someone can manage your affairs if you cannot, without the complications that come with joint ownership. Speak with an estate planning attorney about whether a power of attorney might be a better fit for your situation than adding a child to your accounts. There is one more important topic to cover, and it involves something that is becoming more relevant for older Americans as more banking moves online and as more accounts are managed digitally. What happens to online accounts, digital payment accounts, and accounts where the primary access is through a mobile app or online portal when a spouse dies? The right of survivorship principle applies to the underlying bank account regardless of how you access it. If your joint checking account is managed primarily through an online banking portal and your spouse passes away, the right of survivorship still applies to the funds in that account. What can create complications is the access to the online account itself. If the account login credentials, the username and password, the security questions, the authentication app or device, were all set up in your spouse's name and on your spouse's devices, you may find yourself locked out of the portal even though you have legal access to the funds through right of survivorship. Banks are becoming more attentive to this issue as digital banking becomes more common, and most major banks have a process for helping a surviving spouse establish their own access credentials after a death is documented. But it requires proactive communication with the bank rather than just using your spouse's login. Using a deceased person's online credentials to access accounts, even accounts you have legal ownership of, is a practice the bank's security systems may flag, and that can create unnecessary complications. When you visit the bank to document the death and transfer the account to your name, also ask specifically about updating the online access credentials so that your own login and authentication methods are established as the primary access for the account going forward. Similarly, if you and your spouse used any digital payment tools or apps, whether that is a bank's own mobile payment feature, a third-party payment app, or any other digital financial tool that was connected to your joint account, you will want to address those connections as part of the account transition process. Some of these tools tie access specifically to one phone number or email address, and ensuring that your contact information is the one connected to the account going forward prevents disruption to any automatic payments or financial management tools you rely on. Let us also address the Social Security component of this situation, because for many older couples, the death of a spouse triggers important and time-sensitive decisions about Social Security benefits that intersect directly with the bank account situation. When a spouse dies, the surviving spouse may be entitled to a survivor's benefit from Social Security that is equal to the larger of their own benefit or the deceased spouse's benefit, up to 100%. The survivor's benefit does not transfer automatically. You must contact the Social Security Administration to apply for it. The SSA can be reached at 1-800-772-1213. There are also rules about timing that affect how much you can receive, depending on your age and whether your spouse had begun collecting their own benefits before they died. This is separate from the bank account situation, but it is directly relevant to your overall financial picture in the aftermath of a loss. And addressing it promptly matters because certain retroactive benefit windows are time-limited. The bank account itself, once transferred to your sole ownership, will be where your Social Security deposits continue to arrive. Make sure the bank has your updated account information and that the direct deposit on file with the SSA reflects an account that is solely in your name now, rather than a joint account that has been administratively modified. This is typically handled automatically as part of the account transition process, but it is worth confirming explicitly with both your bank and with the SSA to ensure there is no interruption in your monthly Social Security payment. Let us bring everything together with a clear picture of what every person with a joint bank account needs to know and act on, whether you are facing this situation right now or whether you are reading this while both you and your spouse are here and you want to be prepared. If your joint account has right of survivorship, the funds transfer automatically to the surviving spouse with a certified death certificate and a visit to the bank. The account is not frozen. It does not go through probate. The will does not override the survivorship right. If you live in a community property state, verify the exact titling of your joint account, because community property titling without an explicit survivorship clause works differently and may require a portion of the account to go through the estate. If your combined estate is near the threshold for estate or inheritance tax in your state, consult a tax professional, because state-level thresholds can be significantly lower than the federal exemption. Once a joint account transfers to your sole name, add a payable on death beneficiary immediately to ensure the account can transfer to your intended heirs without probate when it is eventually your turn. Order multiple certified copies of the death certificate early in the process because you will need more than you expect. Revisit your estate plan with an attorney after the loss to make sure it reflects your new reality as a sole account holder. If you have joint accounts with adult children rather than with a spouse, understand the different legal and tax implications and consider whether a durable power of attorney might serve your needs better than joint ownership. Address online banking credentials and digital account access as part of the account transition process so that your own access is established cleanly under the updated account. Losing a spouse is one of the hardest things a person can go through. The financial and administrative demands that arrive in the middle of that grief are real, and they can feel overwhelming. But the bank account piece of this, the part we have spent this entire video on, does not have to be the source of confusion and additional stress that it is for so many people. With the right information, with the documentation in order, and with a clear understanding of how your specific account is titled and what that means, this piece of the process can be straightforward, can be handled within a few days of the loss, and can give you one less thing to worry about during a time when you have more than enough to carry. If this information was helpful to you, share it with someone you know who has a joint bank account with their spouse and who has never thought about these questions. Send it to a friend who recently lost their spouse and is trying to figure out what comes next. Share it with your adult children so they understand what the process looks like and what they can do to help if the time comes. The people most likely to need this information are the people who are not actively looking for it, which means your share is their notification. Passing it along is genuinely one of the most practical and caring things you can do for the people in your life. Disclaimer: this video is created for educational and informational purposes only. The content presented here reflects opinions and general information gathered from publicly available sources, including YouTube, Google, news outlets, and various online resources. Nothing in this video should be interpreted as legal advice, financial advice, tax advice, or professional guidance of any kind. Laws, regulations, and bank policies vary by state, by institution, and by individual circumstances, and they change over time. Every person's situation is unique, and the information provided here may not apply to your specific circumstances. Always consult a qualified attorney, a certified financial planner, a licensed tax professional, or another relevant expert before making any decisions about your bank accounts, your estate plan, your tax obligations, or any other financial or legal matter. The goal of this content is simply to help you ask better questions and be better informed when you do have those conversations with qualified professionals.